Good morning, dear colleagues. We begin. I welcome all those who are with us online, and I welcome our panelists as well as all those who are in Zoom. Today, we are going to discuss an important topic. Justice as a component of peace building, selecting an effective model for Ukraine. I hope that today we shall create a platform for exchange where we'll voice our opinions. And I think we all have our own opinions and have what to impart to others. And I do believe that we'll come up with some recommendations and a vision of how we can proceed in terms of looking for an effective model that will help Ukraine to go ahead with the peace progress. I want to give the floor to Ludwig Smoor, First Secretary of the Embassy of the Kingdom of the Netherlands to Ukraine. Sure. Well, the floor goes to Ludwig Smoor, First Secretary of the Embassy of the Kingdom of the Netherlands to Ukraine. Mr. Smoor. Well, we probably have some technical complications. We'll give the floor to Mr. Smoor sometime later. And I'll begin with my speech in order to outline the context of this discussion. I want to begin with the following thesis. Justice plays a key role in the peace-building processes. There is an opinion that justice with regard to participants of our conflicts while peace negotiations unfold may harm. That's why occasionally such processes are postponed until peace is reached. And the processes of justice become one of conditions, like it was the instance with Southern Sudan or the Sierra Leone court. And such examples are numerous. The motivation here is that justice processes, if initiated at the wrong time, especially when an armed conflict is still underway, may lead to even a greater split in the society. As practice shows, such reservations may be important in the instance of internal conflicts. Today, however, I would like to offer a slightly different view and arguments in favor of the thesis that the process of justice in Ukraine will not be harmful but even conducive to peace as soon as possible, and there are at least two reasons why such view may stand. And I suggest we all think about it, and maybe during the discussion you will share your opinions. So, reason number one. When I was thinking about the nature of the armed conflict in the territory of Ukraine, uh, it it appears to be a secondary issue whether what the policymakers think about it, but anyhow, it's an internal split. And when a whole is split, it means a weakness, and it is easier to manipulate with a part. With the split parts. The specific feature of Ukraine is that, according to some scholars, even the center of Europe is in its territory in the village of Delive in Transcarpathia, which means that here in the center we see an interconnection of the west, of the east, of the south, and of the north. And it also means that Ukraine is extremely sensitive to all the winds that blow from all directions. Putin's regime understands that. On June 18th, 2021, there came out a long read in the Financial Times. It was Henry Foy's interview with Vladislav Surkov, who is considered to be Putin's Grey Cardinal and one of the architects of the armed conflict in Ukraine. And by the way, he confirmed it in his interview. When asked about Ukraine, he said he was after helping Ukraine Kyiv. So let me continue. Later, Mr. Kulkov says, a country may be reformed, this country may be reformed as a confederation with a great degree of freedom for the regions. If there are two bones, there should be some soft tissue between them. Ukraine is between Russia and the West, and very many different discussions occur now about reintegration of the territories separated by the armed conflict, and there are even now some draft laws in the parliamentary pipeline. However, the divide existed even before the armed conflict. There was dissatisfaction, resentment, even hatred, because there is no smoke without fire. Russia used the situation in order to promote its own interest and to expand its influence. It will continue this policy. Thus, Russia increased the existing divide and the amount of resentment and hatred. And this means that if we don't do away with the existing vulnerabilities, Russia may turn out not to be the only country that may try to use it for its own interests. So in order to find, again, the integrity that the policymakers speak so much about, and in order to shield our people against further splits, our policy should center on peace building. We should always look for the assemblage point, for the center of the state's modus operandi, for the center of objectivity and unity. And the symbol of justice is Themis holding the scales. It weighs good against evil, guilt against innocence. Fairness of justice means weighing of all deeds very carefully. That's why effective justice with regard to gravest crimes may become an efficient instrument for restoring integrity. In order to reach such results, all the processes are to be construed not to just formally meet the requirements of the criminal code and code of criminal procedure, but to also restore credibility and unity. That's why justice is an obligatory precondition. The national legal system is a rule, especially if the country is a party to an armed conflict. A priori may not meet this challenge on its own. That's why this capacity should be increased. There are different recipes for Ukraine. Which is in the 8th year of its armed conflict. It's crucial to find an effective model because so much time has already been lost. Wounds are too deep. And not too many believe in the full capacity of the state, especially against the backdrop of the recent developments in the Office of the Prosecutor General. Reason number 2, active role of the Russian regime. According to Surkov, Russians are easily predicting Ukraine's policy and what the policymakers may want to do, and thus they promote the narratives that are useful for them. Objective, transparent, and unbiased justice, especially with regard to the crimes that are committed with the support of Russia or by Russian agent, may become an element that Russia is not waiting for and cannot foretell, because effective processes of justice are a rare phenomenon in the territories of the post-Soviet countries. However, only effective justice processes may become a weapon in the struggle with the Russian Federation. And to make that real processes of justice should also be true. And the symbol in this regard is Themis' sword, the sword she holds in her right hand. The sword is the symbol of spiritual force, a symbol of accountability. It is a sword with two edges because justice not only punishes but also prevents. Our task today is to avail of this opportunity in order to hear from experts and to discuss possible models for Ukraine in order to build peace in this country. That's all that I wanted to impart. And may I try again give the floor to Mr. Smore. He will join us later. Then I begin our first panel. And I give the floor to Roman Romanov, who will moderate. Thanks, Nadia. Good morning. I am very glad that we have this chance to continue the discussion that we began last year. I think that we all are aware that peace building and the role of justice in peace building are topics of standing importance. And it's important for those who like to get together and to discuss the existing resources and capacity. We also have to analyze what we have already achieved. We have to assess where we are now. All that's paramount. I'm very grateful to you for having found the time to join us. We have many different participants from various institutions, and I hope we'll have an interesting and a meaningful discussion. We have planned 2 panel discussions. The first one is about combating impunity for grave crimes and about the capacity of the national system of justice. We are going to assess where we are now, what we have at our disposal right now, what we are doing, etc. And it will also be interesting to cast a look back at the year that has passed to estimate what has. Um, and I think that will be helped by the participants of our discussion, those whom we have invited. So first of all, let us look at the present situation from the point of view of the Prosecutor General's office. This office created a specialized department. We all are very much concerned about the present situation, about the future of this department. So we'd like to hear about what's being done now and what the prospects are. And I gave the floor to Arlina Pavluk, who represents the specialized department, uh, uh, which is to hold to account those who committed grave crimes.
Thank you, Roman. Can everyone hear me well? After all of the discussions ongoing for 3 years now, it's my honor to present the Office of the Prosecutor Generals from the standpoint of an insider's view on the system. And I think I'll be able to share more details about what is going on. First, a few words about the structure that we currently have in 2019 within the Office of the Prosecutor General. There was a department for oversight over the issue of the offenses committed during armed conflict. This is a unique structure, especially given the ongoing armed conflict. The department works with the issues related to the eastern part of the country and Crimea. Inside the department, there are procedural oversight unit and units that are working with analytics, working with data, communicating with ICC. Aside from that, the prosecutors of the Autonomous Republic of Crimea and the city of Sevastopol continues their work very successfully, and we take great pride in the units within the structure of Donetsk and Luhansk Oblast Prosecutor's Office. These units, these departments specifically, are the part of the prosecutorial system that have certain specialization relevant for the events unraveled in the territory of Ukraine, the armed conflict. So they are analyzing the events, documenting all the consequences and implications that take place. Regarding the things that we work with, this is a large number of criminal offenses that have taken place, which unfortunately continue appearing, and a major ordeal for us was that prosecutorial bodies, investigative bodies, and courts, they have to look into events that took place as far back as 2014. So a major factor that is still present in the operations of the national justice system is the amount of the offenses that were committed, the time that has passed, and the time that it takes to conduct an efficient and complete investigation of the events, as well as the amount of information which has to be documented, preserved, and we also have to be mindful of the prospects of the case in Ukraine domestically and international courts. So specifically through this existing structure within prosecutorial system that was formed, and through establishing of the department, we tried to preserve the evidence for the future, the evidence that will be important for domestic proceedings and international as well. Also, amongst the important factors that are significant in terms of the operations of the domestic justice system is quality of legislation. We've been often saying that criminal code requires certain amendments, and the Office of Prosecutor General welcomes the second reading of the draft law 2689 on harmonization of domestic legislation with international humanitarian law, and we expect that in the nearest time the draft will be signed and adopted. The provisions of this draft law will give more opportunities to make decisions about the charges with regards to war crimes in the east of the country, in Donbass. And recently there were amendments to the Criminal Procedure Code with regards to the special pretrial investigation. Last year there were discussions about the need to bring back the mechanism of trial in absentia, and that was suspended, and prosecutors, investigators, they have high hopes on that, this concept in the cases that involve proceedings in absentia. This aspect is quite controversial still, both for the domestic justice system and for international system, given that we continue documenting everything that's happening. We are presenting the cases in courts. However, there's still one outstanding issue about detention and apprehension of persons, and proceeding in absentia is very different from proceedings in the presence of the defendant. However, as of now, this is probably the only efficient tool that helps us show progress, results in the form of court decisions and determinations. There's another relevant issue about other amendments to the Criminal Procedure Code, in particular with regards to the duration of pretrial investigation. And here, what should be mentioned is that the amount of information is important. The number of victims, the number of witnesses, the amount of evidence that has to be documented. And unfortunately, it doesn't seem possible in this case to make it in the time given in line with procedural legislation. It's a pity that the criminal procedure legislation, the applicable legislation, does not give account to that. At the level of prosecutorial bodies, investigative bodies, and courts, there's a need for personnel. They're understaffed. There's immense they're overwhelmed with work in all categories of the cases, but this category that we're discussing, the need is especially grave. And another factor that affects the administration of justice at all levels is the training. The training in the area of international humanitarian law and international criminal law, prosecutorial bodies, courts, judges, investigators are in need of those trainings. And these cases require specific experience and practices. Unfortunately, in Ukraine, we don't have sustainable practices at the moment. Unfortunately, as of now, we only have 2 court verdicts in Article 438 of the Criminal Code, violation of the rules of engagement. And we can say that these 2 verdicts present a sustainable practice. So it's of utmost importance to continue training for different levels of prosecutorial system to make sure the investigations of the cases are efficient. As a representative of the Office of the Prosecutor General, I would like to say that we continue working towards making sure that all of the events, data is documented, making sure that the process is ongoing. And regardless of the fact that one of the key criteria for ICC is the capability of the domestic system to administer justice, to adjudicate cases of armed conflict, regardless of all the complexity of the situation, we are nonetheless trying to do our job properly. We're trying to show that we are very interested to arrive at results and to make sure that the process continues. Thank you. Thank you very much, Alina. I have already mentioned that it was the Office of the Prosecutor General that came up with this great approach towards specialization. They came up with this idea, and it's very important that there's already there are ideas about how the justice system has to develop in the context of liability for grave crimes. There's still one pending issue about how the policy of liability is formed and what is the role of various institutions in this process. I believe for our international partners, it would be really weird to hear the name of the line committee in the parliament. The name goes Legislative Provision of Activities, a complicated name of the committee. This is not a question for the committee. This is rather about the role of the parliament. Because pinning it down to legislative function means that we are stepping away from the expectations at the parliamentary level. There could be the national level policy developed. However, if the function of the parliament is this process is an instrumental one, then it's relevant that there's the question asked about why prosecutorial bodies, courts, they are limited in the range of tools that could be helpful in dealing with the issue of liability for crimes committed during armed conflict. However, if we take a look back, since the last time we met for discussion, there's been significant changes in the area of legislative framework. On one hand, there's some progress. On the other hand, there's still many outstanding pending issues, in particular harmonization of our domestic legislation with international humanitarian law and implementation of the Rome Statute and efficient tools of efficient work for prosecutorial offices in courts in terms of substantive and procedural law. I think it would be interesting to hear from the parliamentary committee at this point, and I would be very grateful to Victoria Mozhova if she could join us and take the floor. The floor is yours. Thank you. Is everything on? Regarding legislative issues, lawmaking and plans, in particular in the context of the Law Enforcement Committee and the issues on our agenda, the issues that were already raised. Not to take too much time, I would like to begin with the draft 2689. This is it was passed in the second reading, the draft law on implementation of international humanitarian law, international criminal law. It should be said that even prior to adoption of the law, there was still ongoing communication. This is quite a sophisticated piece of legislation, quite sophisticated even for those that are voting for it. there was a large number of meetings, and I would like to thank the NGOs that worked with us in this process, that supported it, and the center. I would like to thank the Center of Civil Liberties. I would like to thank UN for all of the communications that they were engaged in. Also, I would like to extend my gratitude to our international partners, experts, through extensive cooperation with the Office of the Prosecutor General, Prosecutorial Office of the Autonomous Republic of Crimea, we managed to pass the draft in the second reading. The communication still continues, and as of now, there's one outstanding issue of improper interpretation of the provisions, Article 31.1 in particular, on liability of commanders. And this is an international standard without which we cannot proceed, which is significant. Because if there were to be international proceedings for Ukrainian decisions to matter internationally, we need to make sure we comply with all the fundamental principles of international humanitarian law. Our decisions need to be legitimate, and this article about liability of the commanders is interpreted wrongly. It is seen as an issue of non-compliance with illegal orders of commanders, so there are discrepancies in interpretations. We didn't introduce amendments there, but there's this controversy in interpretations, and time again you have to go back and explain that this is a matter of illegal omission of action. And step by step, the team is working towards overcoming various obstacles, and we have high hopes for July the 17th is the day of International Criminal Justice, and hopefully this will be the day when Ukraine finally adopts this draft. We're doing our best to make that happen. And let me reiterate once again the importance of this draft in terms of charging of the offenses that take place on the territory of occupied areas. The longer we wait, the less capabilities we have to deal with this situation. The crimes against humanity is missing in the criminal code as a concept, and war crimes are partially present, and the politically important process about with regards to demographic situation in Crimea, the situation with IDPs, the conditions that force them to relocate with regards to sexual offenses, using people as life shields. All of these offenses are charged pursuant to general criminal articles in the code, and there's a period of limitations, different punishments, different sentences, and this all shows that in 8 years, Ukraine hasn't met its obligation before its people, its obligation of protecting its interest, sovereignty, and territorial integrity. So we hope that all of misunderstandings, various interpretations will be dealt with, and hopefully the law will be signed in the nearest time. Another point to make, is period of limitations, the issues around the criminal procedure code in the nearest time. There will be a draft law. It's being prepared, a draft on amendments to the criminal procedure code, in particular Article 219 that was mentioned before. If it's a historic crime of facts, we don't have a notice of suspicion served, we have to close the case in 18 months. So amendments are drafted on that. One more thing to mention. An important step that is going to be quite an ordeal, but we still managed to do it. That was dealing with the issue with proceeding in absentia, and the committee has been receiving information from various sources about assessing the quality of the draft law, about the issues that are still there, about some improvements that need to be made to the draft, and it's actually great to see that piece of legislation working. There are aspects about the appeals procedure in trial in absentia cases, and this was not covered in the draft law, and it's suggested to go back to it in the next draft law to make sure that proceeding in absentia is in line with international standards, to avoid issues of sending cases back to trial in the first instance. So this is the procedure that has to be improved.
10 minutes ago, in fact, one of the parliament members presented a draft law on security and safety of the participants of the process of criminal justice. After 93, this procedure never changed. But now we're in a situation of armed conflict. That's why we have to make safe all the important witnesses. Those regulations that exist now are not efficient. They are not good even for other criminal proceedings, to say nothings of those where human life and health may be at greater risk. So the new draft law will be officially registered shortly. We'll do whatever possible in order to put it through the parliament. This law will abide by the best European practices, including those of the United States and Europe. The entire system of security measures will be reviewed and a special body will be created. 210 people strong, or 260 with auxiliary personnel. And these people will be directly in charge of ensuring security and safety of individuals at great risk during criminal proceedings. The draft law also addresses another important matter. Now we have two institutions involved, and one of them is about personal guards, and the second one is about the so-called alarm button. I'm not going to speak about the latter, but as for the former, we all certainly visualize a situation when a person is always accompanied by two or three other persons who guard him or her, and psychologically it's very difficult to be thus guarded all the time. If a person is guarded like that, this person gets reluctant to participate in the process of criminal justice. That's why we have to think about resettlement, including resettlement abroad, and this is what we are going to prescribe for the instances under discussion today. Shortly, you'll hear more about this draft law. And let me also mention another issue where a lot of work is being done jointly with the third sector and specifically with the Regional Center of Human Rights. That's about the legal status of those who were convicted in the occupied territories. By the way, articles on reinstatement of criminal proceedings will also be reviewed. And another aspect also deserves mentioning. The issue is that the temporarily occupied territories criminal offenses are being committed. The rights of our citizens are being violated. And many criminals hide in those territories. Oh, those who commit crimes over there can hide then in the territory controlled by the Ukrainian government. In the occupied territories, the unlawfully established law enforcement quasi-authorities operate. In other words, international cooperation is just impossible. And when a person comes to the law enforcement to complain about an offense committed in the occupied territory, our law enforcement can just register that crime and can do nothing further in terms of human rights protection or in terms of interviewing or interrogating other individuals because doing that may discredit Ukraine's interests. This issue is often mentioned by the civic society, and it's important to initiate amendments to different conventions on international cooperation. And let me address two other aspects before I complete my speech. We are well aware of the procedure of the ICC. The issue of Ukraine's occupied territories is being examined. However, over these 8 years, in spite of Ukraine's commitment of 2015, when the right to administer justice was handed over to ICC. In other words, Ukraine handed over part of its jurisdiction, but we don't have any mechanisms in our Code of Criminal Procedure or elsewhere that would ensure proper interaction with ICC. Therefore, when such mechanisms of cooperation appear and when relevant working parties and groups are established, when foreign representatives begin proceedings in the now existing cases, they will bump into the lack of regulations about the procedure. Ukraine recognized all the relevant provisions of the Rome Statutes, including the obligation of ensuring effective cooperation with ICC. So in spite of what progress is being made, it's important to be ready, and if proceedings are opened, they should not be hindered. And one last thing, the attitudes here are different, especially in terms of communication about it, yet our parliament members should say their say. As you know, several courts are now hearing certain cases that have to do with the occupied territories. Some of such cases are about torture. United Nations Court, ICC, and European Court of Human Rights can hear such cases depending on what convention is invoked. They are the same cases, evidence is the same in each instance. Yet we don't have a body or a platform to coordinate all the action in terms of bringing together the actions and activities of all stakeholders and parties in involved. Georgia was making that point several years ago. They agreed on the need to create a coordination platform to avoid different interpretations of certain offenses. Uh, and what I said about the Code of Criminal Procedure and the upcoming amendments in the forthcoming 2 months, a draft law on statute of limitations will be registered, as well as on reopening the proceedings. And these are the most important things that have to do with the work of our committee. Thank you. Thank you, Victoria, for your survey. You looked at the agenda at different angles, covering even what should be on the agenda of the Standing Parliament Committee. In terms of the procedures, quite a lot is yet to be done. Certain changes have occurred during this year. I mean, over the time after our previous conference, uh, Article 438 brings us close to the international criminal law standards, and I refer to those 2 verdicts, and we still have only 2. So it's hard to speak about any sustainable case law, although the armed conflict has been lasting for several years. We all understand that there is no quick way to resolve the conflict, and that's why we need as many mechanisms of response as possible, because it corresponds to the vital interests of Ukraine. It is most optimistic that the committee is giving attention to security and safety of the participants of criminal justice processes. Our foundation initiated a piece of research. We discussed this matter with judges in Donetsk and Luhansk region who hear cases related to the conflict. And this was the question we heard most from them. And as regards this swarm of problems, it is very expedient to now to hear from a judge, Sofia Danilev, judge of Krasnoarmeyski District Court of Donetsk region, is to be with us. Good morning. We hear you, so the floor is yours. And we want to hear what a judge thinks, because for you it's not theory, but it's your daily practice. Good morning, dear participants. I apologize for the poor connection. And I also want to make a caveat that what I say is reflecting only my personal view. So the judgments of the European Court of Human Rights are most important for us Ukrainian judges. The European Court stated that it is possible in theory to hear a case in absentee, but the punishment is to be not more than 5 years. The crimes that occur in Donetsk and Luhansk region and those parts with it are occupied are punishable by more than 5 years of imprisonment. Can you hear me okay? Yes, could you please speak not that fluently because of interpretation? Oh, I am sorry. I know that I do not have too much time. So, the big issue is notifying a person charged with a crime because we have to send the notification to the officially registered address, which we cannot do. Those individuals who have committed crimes or are suspected thereof are mostly in the temporarily occupied areas. After 2014, the Ukrainian Postal Service is not delivering mail over there. The notification is thus posted on the website of the court, but it is hardly believable that a person suspected of a crime will be reading such resources. Another big issue is that individuals who are suspected of crimes cannot make use of legal assistance because those who represent them in court cannot get their consent and have no chance of representing their interests in courts. Lawyers perform on their own without knowing anything about the opinion of the suspect. It cannot be established whether the suspect is really unwilling to participate in the court hearing. It can be just presumed. However, if a person was not notified uh, about the hearing, it may mean that the rights of this person will be violated. Uh, all these are procedural issues. As for evidence, we have an issue with the assessment of evidence provided by the prosecution according to Article 258. They are usually screenshots and recordings of conversations on the phone. However, no forensic expertise is conducted, and it's hard to say whether the voice is really that of the suspect. Due to modern technologies, it is possible now to present any photographs as attachments to the documents, but can that be recognized by a court? Since we are discussing procedural matters. I should also mention that it is nearly impossible to initiate international search of an individual, and that means that many proceedings are discontinued. Since I have this chance to speak here today, I want to disprove an opinion that is often being disseminated. It is the opinion that allegedly judges of our courts are hearing cases under pressure. It is very sad that such information is being spread by representatives of other authorities or by NGOs because some judges who are IDPs from Donetsk have relatives in the occupied territories. After June 2014, Many prosecutors and police officers were moved to other locations, while many judges had to continue performing in their places of engagement until December 2014. Only after that, judges were moved to the courts in the Dnipropetrovsk region, etc. Yes, quite a number of judges have relatives in the occupied territories. And some of them had to travel there, but usually in order to bury their parents. This is when some of them were apprehended by the quasi authorities of the occupied territories. And as for the property issues, in 2016, the law on the judiciary was amended, and all the judges from Donetsk and Luhansk region underwent attestation and had interviews with members of the qualification commission for judges. The point that I want to make is that all the judges took their oath, and the fact of some property being located in the occupied territory does not affect the performance of our judges. Thank you.
Thank you very much, Sophia. Of course, we see all of the presentations today as personal opinions of our speakers, but it is also important for us to see opinions from a standpoint of a representative of a prosecutorial office, representative of a court system, and the combination of these views and opinions helps us paint the picture and see the picture of what is of concern, what still remains to be done, what still remains a task for the future for various stakeholders interested in making sure that prosecuting for grave crimes was efficient. There's something that we touched upon, one of the most complicated issues as of today, which is still unsolved, is finding political will to find solutions. And it looks this way that it's very hard to answer the question about where the centers of decision making are. And by far and large, we're hostages to very situational ad hoc decisions that are made in various institutions. And the uniform national policy remains an unsolved issue. Maybe not. I think NGOs have a very important role to play in this process. Victoria, in her presentation, mentioned the advocacy and expert role of NGOs, which led to good results in the voting for a draft that is seen by many as quite controversial, the amendments to the Criminal Procedure Code of Ukraine. And the major role was played by NGOs, civil society organizations. And it looks like this role still remains relevant. And I think at this point it makes sense to hear from the representative of the Center of Civil Liberties, Ms. Alexandra Matvichuk, She and her organization did a lot to help us stop being hostages to situational decisions and instead help form a certain vector, direction of movement in the country. And the issue of liability for grave crimes did not remain a merely issue of theory. Alexandra, the floor is yours. Good morning, dear colleagues. Indeed, I am from the Center of Civil Liberties, and our organization coordinates the platform of civil society organizations, human rights agenda. This is what it's called, and one of our purposes is combating impunity and improving legal framework of Ukraine in order to provide proper legal documents to combat this phenomenon. We try to be pragmatic in working with the issues that Ukraine faced years ago when it broke them into two categories. First is the reasons that Ukraine cannot have any impact on, and secondly, these are the reasons that Ukraine, with regards to which Ukraine has an obligation to handle them, ratifying the Rome Statute in particular, harmonization of the domestic legislation to the provisions of international humanitarian law and international criminal law. In terms of the absence of political will, and the topic of my presentation is specifically political will and providing efficient justice. This reminds me of the quote from Francis Fukuyama. He said that instead of looking for political will, try to look what the word stands for. And I've been working with the issues of advocacy, of change to criminal law, and I can say that in Ukrainian context, what this phrase means is that unfortunately, during previous government and current government, combating impunity is not a priority in the national policy. Moreover, these positive change that take place in the area of public administration, they are based merely on enthusiasm and work of specific people. The the presidential team achieved some progress in the issues around Crimea, and there was a lot of progress from the team of Genduz Mamedov, Office of the Prosecutor General. We can mention some MPs, head of law enforcement committee, Denis Monastirski in particular, but we can see that the system does not support this enthusiasm and does not protect it, and there's suspending Genduz Mamedov from heading the International Crimes Department actually shows that. And since fighting impunity is not a priority in the national policy, and this causes the lack of political will, the major progress happened thanks to the support of international community. The history behind draft 2689 that was mentioned today is a vivid example of that. The human rights agenda there were two declarations submitted by the parliament in 2016 through the work of the human rights agenda, and civil society organizations led to amendments to the Constitution, amendments to Article 126 of the Constitution that open the road to ratifying the Rome Statute. And unfortunately, the MPs haven't used the opportunity to ratify it. And 5 years ago, we launched a work group that drafted a bill to harmonize the CPC with international humanitarian law, international criminal law. And in the previous convocation of the parliament, it passed the first reading. And then the draft law, the amended, was registered with support of the head of the Parliamentary Committee for Law Enforcement Committee, passed a second reading, and presently it's pending signature from the President. And I agree with the previous speakers. We hope that by the Day of International Justice, the draft will be signed off on. But this was a major effort. It was complicated, and it's past time that the presidential office had to sign the draft law, so it's a bit unclear what the decision is. We're trying to convince the presidential office to sign it, but we don't know when that is going to happen. I would like to conclude by saying that the national policy looks strange because on one hand we're trying to tell the partners about how we are trying to fight the crime, but we're not doing much to do it. Recently there was a meeting between NGOs and representatives of EU on the human rights dialogue, and EU representatives told us that Ukrainian government told them that there's no progress in the Rome Statute, but instead they reported on 2689 draft, but it wasn't even at the stage of the second reading at that point. I should say that ratifying the Rome Statute, passing 2689, this is something that we need not only to meet Ukraine's international commitments, it is needed to make sure that we provide justice and fairness to the victims of the crimes, because if this need is not met, then the need for justice might turn into need for revenge. We constantly work with the victims of war crimes, and our organization in particular specializes in survivors, prisoners of war, or victims of political persecutions. And I know for a fact that people who survived, the survivors of tortures, they need not so much restoration of, say, their health, housing, infrastructure, broken family ties. What they need, first and foremost, is assurance, seeing that the law works, that the conflicts can be resolved within a legal framework in line with it. And we believe that the voice of those for whom these laws need to be passed was heard, and the priorities of the national policies need to shift towards them. Thank you very much, Alexandra. I would like to bring your attention to what Alexandra mentioned at the end, the view of the situation, seeing justice through the eyes of the victims. In most cases, we're looking at this as institutions or experts. And if we overlook the victims, then justice itself becomes something else for us. It's no longer a value that is aimed at restoration of rights, encouraging people to rely on the domestic justice system when bad things happen. And an armed conflict, unfortunately, is a source of suffering for very many people. And these are crimes that have been committed, are being committed. And I think that without resolving issues around the armed conflict, there will be no stop to it. It's not going to cease. So this is the point of view that we have to be mindful of. And another thing that we have to remember, that these are specific people whose rights were violated, victims of the crimes, and we need to put oral effort towards that. I would like to thank all of the participants of our panel. And I'm very happy to open the floor for a discussion. I think it makes a lot of sense given that we heard various points of view. We took a look at where we are now, given our previous discussion a year ago. With us in the room and joining us online, there are a lot of people who have their opinions that maybe we haven't yet heard so far, or maybe their opinions that can be in disagreement with what was said. So this is a great opportunity for discussion. I will be moderating it. Please take the floor if you want to speak. To discuss the issues that were raised in panel discussion 1, please raise your hands. This is for those of you who are with us in the room. We'll pass you the microphone. And for our Zoom participants, please let me know if you'd like to speak. Unfortunately, I'll have to limit you in interventions in time. You have 5 minutes most for each intervention. Please try to be succinct. I can see Yevgenia Zakrevska. She's a lawyer, representative of the victims in many proceedings. Are victims of the armed conflict. So Yevgenia, the floor is yours. Good morning. Yes, that's true. I raised a hand because we started talking about the victims, and I believe that without active participation and involvement of the victims, the prospects of the cases are bad. The victims and the survivors are eyewitnesses of the offenses, and their testimony is a source of evidence, and the information received from them very often is a starting point in many investigations. Without them, there's no investigation, no prospects for such investigation. And the issue of victims in the period since 2014, and I have to mention that I have been working with that from the very beginning, and I went to work with the victims on the occupied territories. The situation changed for better, and the reason for that, the way I see it, is active operations, the commencement of the active operations of the Crimean Prosecutor's Office. That was in 2016, 2017. And then establishing one unit in the Department of War, the way we refer to it. So let me explain the difference to you. Prior to having a unit of procedural guidance, I had to coordinate a large number of law enforcement bodies police precincts that opened a criminal case based on someone's statement. Then they would close the case with some evidence in the case, but the evidence is something they cannot transfer to anyone. So I had to look into the case, write a motion to the Security Service of Ukraine about the status of the proceeding, for them to pay attention about the evidence, that the evidence is there, that this has to be done. And then times and times again, and it was actually once 5 times, when one of the witnesses was interviewed 5 times by different bodies, different authorities about the same events, making him explain things, and he already did that. So that's re-traumatization, and the more the further along the way from the event, the less accurate the account of the events is. And there's a lot of coordination that has to be done. And the absence of proper coordination impedes the efficiency of investigation. There were a lot of cases investigating the same event. And this could be a violation of the principle of double jeopardy, nibis in idem, and of dealing with the status of witnesses. That was an issue that was relevant and a problem for Security Service of Ukraine.
And all that creates procedural issues. When a witness is telling the law enforcement how he was battered, that is not really about his status as described and specified in the criminal code. I am very glad that witness protection programs will appear. It's very important because victims are very much afraid. Many victims were the same witnesses, but they are afraid to testify. They have to be somehow motivated. They don't trust the law enforcement, and they had good reasons to do that, because some evidence may have been lost because they have observed absence of proper coordination, and all these are very ailing issues. So if the Department of War collapses, everything may get back to the zero level of before, and we won't have any prospects of cases getting to the court or being disposed there. And I want to make yet another point. The attitude to victims, as it should be, does not boil down to the criminal process. Victims provide important information about what it was like to be a prisoner. That information may be further used in international court, but after that, they have to prove what they have said in a court here in order to get the status of a former prisoner, while SBU, the police, or the Ministry of Reintegration cannot put that information together or verify it appropriately. As a result, that may unmotivate victims and urge them not to participate in criminal proceedings. Thank you. We're just casually giving some attention to the issue of victims and of survivors, but I do hope we'll have opportunities to return to this aspect later. I want to give the floor now to Olga Reshetilova from Human Rights Media Initiative. Good morning, dear colleagues. Thanks for this event. Not too many platforms exist where we can raise such important topics and only such a resonant happening as the attempt at destroying the Department of War catches the eye of the public, although we all are doing very important things together with the prosecutors from the Department of War or from other prosecutors' offices. Our organization has been monitoring investigations in war crimes as well as in crimes implying threats to the national security of Ukraine. Let me say something about how these offenses are qualified. After 2014, this process was very much chaotic. Uh, Sometimes in an article we see a prompt that an offense was related to the armed conflict, but to 215 or 146 does not have any note that what had happened had to do with the armed conflict or hostilities. And therefore neither the media people nor the broad public get a signal that this case should be monitored. I wrote an article which contains a number of recommendations for the judicial administration and for the law enforcement bodies about maintaining separate statistical data on such cases for the public to be able to monitor such cases in a better way. But no statistical data at all is available now. We really don't know the exact number of cases, and only with the establishment of the so-called Department of War, the effort became more systemic, and prosecutors from their department started collecting all the proceedings from different authorities and started doing re-qualification with the invoking of the standards of IHL. But as soon as we started seeing some systemic effort, this effort became endangered. I want now to reply to the remarks of the judge from Donetsk region. She complained about the impossibility of making a suspect wanted internationally. She also referred to in absentia convictions. I know that attitudes differ and many discussions may occur, but the law was adopted, and now judges are free to act. And may remind you of a story which illustrates that even without the political will or with it, some judges could pass their decisions. It's about Svetlana Savchenko, a case from Crimea. That woman was convicted by Judge Didchuk from Svetoshinsky Court of Kiev for high treason. She got 14 years of imprisonment. On the very next day after the verdict, she wrote about the trial on her Facebook account. She wrote about lack of justice in Ukraine, about her in absentia verdict, etc. Then she hired a Ukrainian lawyer who appealed, but he missed the deadline. The Court of Appeal dismissed the appeal. So then her lawyer in Russia went to the Supreme Court of there and complained about his client having missed the deadline. The journalists drew attention to that. It was the lady herself who wrote on her Facebook account that she was convicted, and then her lawyer started alleging that she was unaware of the conviction. So this is a very illustrative episode. In accordance with the procedural standards, it's real hard to notify a person that this person is persecuted in absentia. But for us media people, it is utmostly clear that those people are well informed and they are closely following the processes in the Ukrainian judiciary that unfold here in Ukraine. But what is important in these cases is that the Ukrainian justice is saying its say about war crimes and crimes against humanity. And another thing I want to say about is communication. Communication by the involved authorities and between experts. This society remains largely uninformed about trials related to the armed conflict. Yes, we work with the Department of War in terms of better communication with the society, but all judges should also remember that they have to explain their judgments and verdicts, and they have to avail of the services of press secretaries of court to communicate with the society. I'm told that Judge Danilev wants to join the discussion because her speech was quoted a couple of times. I want to comment on the remark that that judges think it impossible to declare suspects wanted internationally. Judges pass relevant decisions in accordance with the code, but they cannot do what is not established by law. Let us respect the law, whether they like its content or not. As for victims, yes, it is procedurally difficult to interview witnesses who reside in the occupied territories. Video conferencing is a possibility, but it is not always possible to establish the identity of the person on the screen. This person may be asked to show an ID, which is not always a passable solution. Verkhovna Rada of Ukraine did not have enough political will to amend the legislation in order to minimize all these negative phenomena in Donetsk and Luhansk region. Issues are numerous, but not the judges pass the law, but the parliament members, judges apply. Sadly, the connection was bad and we did not hear everything, but I hope we heard the key things. And now I give the floor to Larissa Denisenko, lawyer and writer. over the last time she's been involved in communication regarding proceedings related to the conflict. I see that Evgeny and Olga want to respond, so give them a chance to respond to this discussion, and I can take the floor later. So, Ola, Evgenia, 30 seconds for your remarks. I want to quote an example. The MH17 proceedings. I want all prosecutors and judges to be aware of it. Cases from the occupied territories cannot be the same as all other cases. Judges have to be more creative here in terms of interpreting evidence, in terms of the presence of lawyers, in terms of the freedom of witnesses giving their testimonies. These examples are very convincing, and I would request you to involve all the stakeholders, because that will certainly increase the quality of justice. The judge said that the issue of pressure on judges is exaggerated by many, but we've seen dozens of motions from judges on self-recusal. They allege that they are under pressure or may be pressured because their relatives reside in the occupied territories. If no such pressure exists, then some judges do abuse their right to self-recusal because of pressure. And I understand why all that is happening, because very often, if there is a case related to an armed conflict and the proceedings are in absentia, then judges often have two cases at the same time, and they don't conduct hearings and postpone them with no sound grounds. Thank you. Dear colleagues, I want to refer to 3 points from our discussion. Support of the government and the political will. We understand that many markers are quite clear to the society, and they prompt the society whether political will is there or is absent. Do we have a policy regarding effective investigation of this category of cases or not? And if such a policy exists, what it is like? So one of the markers, in my view, was the president's signing of the law that we are discussing right now. It's important from the point of view of communication, because the president is the supreme commander of the armed forces of the country in war, and he is also the guarantor of all rights. Therefore, the fact of the law being signed is a warranty that in our country, which has been living in a conflict for 8 years, is properly recognized by the authorities, and that not only the War Department of the Prosecutor's Office is being involved, and many, by the way, don't understand how this department works and what it is doing. But these political steps on the part of the head of the state do testify that this realm is in the focus of attention, and will remain in the focus of attention. So this is the marker, and this is also the message to the entire society. All relevant policies should be sensitive, systemic, and continuous. And if there is any step taken, after which the Department of War loses its procedural guidance powers. That's hitting the unity efforts and all the prioritization attempts, and the President of Ukraine should be aware of that. Pretty often we uh, speak about the ideas and opinions of the people who observe the developments. Very polar opinions have emerged after the recent developments, and I think you can imagine how the signals are perceived in the society, especially by those who are disillusioned and frustrated. There may be 5 experts who specialize in criminal law. Some of them are more public, some are more popular than others, and laymen who hear their discussions just get entirely confused. Just try to imagine what a person in the street will think should this person decide to understand what's going on. And as for justice, we really have very polar attitude to the war per se, to its consequences per se, and to the law and rights. And the notion of justice is something utterly individual. Yevgenia was very much correct when she was speaking about victims. Mentally, those people who are in the occupied territories all think that they are victims. They believe they are victims of the present policies of the Ukrainian government. Reintegration and deoccupation processes will not make these people feel and think differently. They will keep on considering themselves as victims, and this is a socio-cultural issue that deserves attention and effort. And what the Department of War is doing is very important, especially in terms of the trials, of the proceedings. I am not saying that judges should immediately or ASAP deliver a dozen or several dozen verdicts. But if investigation is being conducted in the classical format, if the judicial hearings follow also in the classical form, the people will understand how all that functions. And there is something for all of us to do, for the stakeholders, because it's on us that the model of justice perceived by the people depends. And it will be much harder for us in the future if now we ignore some important aspects. We should not ignore anything, then it will be easier to explain to the people all the complexities of the law. And the people will just feel that the state and the system of justice are attentive to these matters, that human rights and freedoms are within the domain of the national security interests. Now many speak about national security interests as something separate from human rights and vice versa, while human rights and freedoms constitute directly a national security interest, and we are not to forget about that, whether in communication or in the judicial sphere in terms of war crimes. Thank you.
Thank you, Larissa. Larissa mentioned the president. Fortunately, he was unable to join us, but we have the first deputy of the presidential representative in the Autonomous Republic of Crimea, Nadia Svedidova, and she would like to take the floor. I think we have every reason to hand it over to her. The microphone is off. The microphone is off. The interpreters cannot hear the speaker. The microphone is off. Interpreters cannot hear the speaker. Can you hear me now? Thank you. Independence of this work from the processes in the justice sector. When we joined as representatives of the president 2 years ago, we were faced with many challenges: institutional development, in-service training, development of the national policies with regards to Crimea. So that one voice and being on the same page that is necessary for the governmental bodies in the area of reintegration and deoccupation. There's certain progress in that, with major support from civil society, NGOs. There's the strategy of deoccupation and reintegration of the temporarily occupied territories of Crimea, and there is a number of laws adopted that rectify certain gaps in the legal framework, some gaps with regards to the inhabitants of Crimea, the piece of legislation on the indigent people of Crimea in particular. This is very important in the context of working with people. I agree with Larissa. It's not enough to adopt a strategy, pass a law, and it is not enough to show within the legal framework that government has a certain standing, even though for our team it is one of the important objectives. But at the same time, we are aware that our institutional capabilities and developing measures to improve trust from the people depends heavily on the capabilities of the prosecutorial office of Crimea, their capabilities to perform their functions. In recent years, we've been actively communicating with people from the occupied territories, and the number of requests to the Office of the Representative went on the rise. In 2 years, there have been around 9,000 requests from the people from the occupied territories, and a vast majority of requests was about the violation of their rights, offenses committed against those people. They come to us, and what we do is we say that fortunately, Ukraine reinstated law enforcement, justice bodies that have to be responsible for documenting and investigating the grave crimes. And the fact that the government states that documenting investigation is a must-have, it's mandatory, it should go hand in hand with specific actions. And the actions is something that's up to the investigative authorities and prosecutor's office of Crimea that are there to pick it up, and hopefully they will only get stronger, because this is not just about our objective. This is not just our policy. This is this is the need of the people. And while working on developing measures on deoccupation and reintegration, we and the partners conducted a major research. Hopefully, we'll be able to present it soon. And the survey showed that one of the major expectations of the people for the measures that will be taken by the government after restoring control of the occupied territories in Donetsk and Luhansk Oblast and Crimea is liability for grave crimes, war crimes, crimes committed on the occupied territory. This is as important for the people as restoring infrastructure in those areas. So therefore, yes, we see proper development of work in the area of justice as important as the objectives that we're faced with in terms of development of the national policy of reintegration and deoccupation. Thank you very much, Daria. You see, it only takes giving the microphone to people from Crimea, and that launches a chain of speakers, because I cannot help but hand it over to Igor Panuchevny, head of the prosecutor's office of Crimea and the city of Sevastopol. Thank you, Roman. I would like to say something building on what Larissa was talking about, building on what Yevgenia, Olha said, as well as the judge. Based on my experience, I can say that Kyiv courts hear most of the Crimean cases, and I believe that there's insufficient communication between judges. And judges, there needs to be more focus on the importance of indictments in the cases. And indeed, as Olha said, Crimean say when the hearings are appointed 5 minutes one after another back to back. So this shows that there isn't going to be much attention paid to those who will be taking the stand. So it shows that there's lack of serious treatment of in absentia proceeding. And I think this is not to put blame on the judges, but the thing is that the judges weren't explained properly the importance of the issue, because to tell you the truth, without having worked with the issue of crimes committed in armed conflict, having worked with general crimes in the prosecutorial office, I barely had any idea about what trial in absentia is. After I received certain knowledge and experience, it became clear to me that these processes are quite sophisticated and important. However, other law enforcement and the judiciary lacks understanding of the matter. And fortunately, when the proceeding in absentia was restored and brought back, there were many opportunities to go to courts, to talk to judges and explain to them about these cases. And Judge Dechuk, that was mentioned today, he should be used as a role model. I think he needs to be engaged in such events for him to show that this can be done. And if prosecutors, investigators did their best to serve the notice to the person of the occupied territory, inform them they're being suspected or charged with a crime, but due to objective reason this information never reaches them, and there's no one to blame in law enforcement or investigating bodies, because we did our best. This was mentioned before by the UK lawyers that work with ECHR, so we do our part of the job, and then it's up to the court to pick up. And the same goes for what was said about prosecutorial offices, investigators working with cases related to armed conflict. One should not expect fast results, because these cases are different from other cases. This was said on more than one occasion, but unfortunately the situation hasn't changed much. The period of limitation is the same for a shoplifting case and an offense committed in Crimea. The period of limitation is the same. And the judges, the leadership, they see no difference in the cases, and at times you have to explain in court why, say, Crimean cases cannot be solved in a few months, and the time frame has to be extended. And the criminal procedure code is an issue here. In the course of the recent 5 years, there's been much added to it, adding to the complexity of the regulation of law enforcement. At the end of the day, we are fighting not the other party in the proceeding, but the CPC. It's much easier for the lawyers in the case, because they don't necessarily have to do anything. They have to wait for the pre-trial investigation bodies to bring a case to court and wait till they mess it up, because there's a maze and labyrinth of complexities and sophisticated issues that it's very hard to meander in. So I think there maybe should be a separate law or maybe transitional provisions in the CPC on those crimes, because investigating the crimes on the temporarily occupied territories in line with the regulations in the CPC is virtually impossible. And this brings up the issue of efficiency, because there's barely any efficiency. And I can agree with what the judge has said. She said that they have to act in compliance with the law within the legal framework, and blaming them, they are turning a blind eye on some offenses. This is something that cannot be done. Well, this is a matter of their responsibility. So the legislation has to be amended, and we need to look at MH17 case and other international cases, because the procedure is much simpler there, and it gives more freedom to law enforcement, to the defense. It makes their rights more equal. And experts in IHL find it appalling that I have to use documents corroborating that Aksionov was aware that he was committing a war crime, that his intent was not just to sign a decision on nationalization of Artsakh Children's Camp, but that his intention was to commit a war crime and intentionally violate Geneva Convention. So I have to produce a document corroborating that. So that's how absurd it gets. Thank you, Ihor. These were some very important issues that bring us back to the title of our session, looking for efficient model for Ukraine. And it has to bring solutions to various issues, specialization, various procedural issues, and the absence of those solutions is quite a hurdle. On the other hand, I remember the days when the concept of criminal justice was developed and the concept of the new criminal procedure code was drafted. The idea was to take a step back from bureaucracy and to switch to a more adversarial procedure, to make court a key institution in decision making. But later on, throughout all of these stages, we see the return to the bureaucratic model with this formalistic approach to evidence. And I think that the category of war crimes and crimes against humanity in and of itself undermines the very approach, and this in turn brings us to a whole new level of discussion. The national policy, the model, and the efficiency of prosecution's liability. I know I'm between you and the coffee break, but we were a bit late in the beginning, and we have one more speaker. After that, we'll go on the break, and we'll start the international part of our discussion, which I believe will be no less interesting. Anna Vishnyakova, Ukrainian Legal Advisory Group. Good afternoon. I'll just take a minute. Let me bring your attention to one technical issue: translations of Geneva Convention and other treaties, international humanitarian law. Not everyone is fluent in English, and the quality of translations is bad. And it's not so much only about the absence of articles translated, Article 51, for example, but at times the translation is completely inaccurate. So it's an absurd situation that Radagov.ua, the website, has translations with mistakes, and UN said it's still in Russian, and it's absurd that 8 years into the conflict, this is like an elephant of the room. This is the kind of the problem. So everybody knows about it, but we don't talk about it. So, and I think that in terms of legislation, some procedural aspects, it takes much more effort to rectify, and we need to do something on our own without relying on others internationally. And translation is something that we can do on our own. So it's the least we can do, handle the issue of translations. Thank you very much. Thank you for this very important aspect in our discussion. Very often we say that the blanket nature of the provision lets us apply international law, but on the other hand, if the quality of translation is something that gives us a completely distorted idea of what was in the original, this means that it's quite a complication. There's a message from a judge from Donetsk Oblast, Sofia. She responded to our discussion. She said, I have no right to comment on the court decisions, orders about self-recusal. In terms of communication, in each court, there's a speaker judge, judge rapporteur. The cases appear on the website of the judiciary. In Donetsk and Luhansk Oblast, there's enough information on the internet. So the discussion about the proper format of communications, about what should be efficient to respond properly to the interest of the public, I believe this remains an open question. And now it's time to go on a break. After that, we'll be back. And Nadia Volkova will be moderating the next session. Thank you.
lineup of brilliant speakers with us today. And welcome to the second panel, during which we are going to discuss practical solutions and recommendations, what we all have to bear in mind for when we start developing an accountability mechanism for grave international crimes, and of course how it should engage with other existing mechanisms. So I'm going to start by introducing our speakers so that you all have a good idea of who we have with us today, the level of expertise. I think it will be useful. So first up is Rod Rastan. He's legal advisor with the Office of the Prosecutor, and in the past year he has been an acting head of the preliminary examination section at the OTP. Then we will have Toby Cadman. Tommy is an international law specialist in international criminal and humanitarian law, international human rights law, and other fields of law. He is also a co-founder of the Guernica Group and joint head of chambers at Guernica 37. Toby's experience is of particular importance because he was one of those who was actively involved in developing the work of the prosecutor's office in the field of international criminal justice in Bosnia. And from our previous discussions with him, it is clear that Ukraine faces a lot of similar problems, which I'm hoping he will be addressing today. And in fact, Toby was supposed to come for a visit to Ukraine and to do the assessment and with a view of providing recommendations to the department, the War Crimes Department, but unfortunately due to the current circumstances we had to postpone his visit until further notice. Another very wonderful speaker who we will hear from is Dr. Fidelma Donnellan. Dr. Donnellan is an Irish lawyer and has managed the strategic and organizational establishment of various war crimes tribunals during her career in international justice. She serves as a registrar of Kosovo specialist chambers since 2016. Dr. Donnellan has managed to set up a funding strategy of the Bosnian war crimes, organized crime and corruption chambers, and the successful transfer of cases from the Yugoslavia Tribunal to the new court. She authored the expert report on and designed the residual special court for Sierra Leone. As the head of KSC court planning team, she's managed the strategic and organizational establishment of the chambers during 2015-2016. Dr. Donnellan served as deputy registrar and acting registrar of the Bosnian war crimes, organized crime and corruption chambers, and as deputy registrar of the special court for Sierra Leone. And last but not least, we will hear from Matt Kanak. Matt's been the head of Amnesty International Center for International Justice since 2015. Prior to that, he was a senior legal officer at the Coalition for the International Criminal Court Secretariat, and he's very experienced in advocating the international justice-related issues before the international community organizations states. So, my first question is to Rod. In light of the recent events and the current state of affairs surrounding the situation in Ukraine and the ICC, and I refer to the decision by the former prosecutor Fatou Bensouda to conclude the PE but not to submit the request for authorization to the pretrial chamber and reasons for such decision, is the ICC panacea for the situation like Ukraine? And according to your assessment, what level of engagement and cooperation would we expect from Ukrainian authorities and Ukrainian civil society in order to ensure an effective and impartial accountability in a situation in Ukraine? Thank you.
Colleagues who will speak after me, Toby, Fidelma, and Matt, will probably have the best insights in relation to the topic we're discussing, but I'm happy to participate in terms of the announced in December that the legal and factual conditions are met for opening investigations. She recapped our previous findings, as you know, on subject matter that we found reasonable basis to believe war crimes and crime against humanity have been committed by different parties to the conflict, both in relation to the events in eastern Ukraine, where we focused in particular on a number of shelling incidents, conduct of hostilities, allegations, as well as crimes in detention. And of course, also in relation to events in Crimea. So our threshold determination that there are crimes within the jurisdiction of court was already previously announced. And this year, she also announced that as far as admissibility is concerned, which is the other main criteria, in terms of gravity and in terms of national proceedings, also the conditions were met. Gravity is probably self-evident, but in terms of national proceedings, although there were some proceedings, and of course we continue to encourage those proceedings, and a number of those also did address some of the conduct which we had looked into in relation to also detention-related conduct or proceedings opened in relation to shelling incidents. Either those proceedings hadn't been able to progress and had stalled, although there were some that had progressed, or otherwise largely the authorities on both sides, one could say, were unable to proceed with those investigations, typically because they didn't have access to the territory where the crime occurred, or to witnesses, or to be able to otherwise carry out the proceedings. And this is an assessment which we also put to the Ukraine authorities, and we also sought to engage with the Russian authorities. And our assessment is this is confirmed by the current status of the proceedings. So as things stand, the prosecutor's office at the court stands with the pre-examination concluded, meaning the criteria are met. And then the next stage is indeed to file an application to proceed. Because Ukraine is not a state party, as you know, only state parties can make a referral to the court, meaning that they can request and then the prosecutor can simply proceed. If a state is not a party but has lodged declaration, such as the case of Ukraine twice, then this is not equated with a referral. This is not the same as a referral. In this instance, the prosecutor has to seek authorization from the pretrial chamber to proceed. So the procedure is slightly different, slightly longer. But the main point is that the next stage now for the prosecutor's office is to proceed to file the Article 15 application to seek authorization. And that process normally takes 3 or 4 months for the judges to rule upon. The outgoing prosecutor, she didn't take a decision not to proceed. She just said that the next stage now is to proceed. And she announced on the same day, the same conclusion, both with respect to Ukraine and Nigeria. But she also said quite openly and honestly that how do we practically do this in a context where we don't have the resources to carry these things out? We are faced at a breaking point in terms of our current workload. We have more cases in trial and in pre-trial than ever before. We have just recently opened investigations in the last year or two in relation to Bangladesh, Myanmar, Afghanistan, and now Palestine. And more recently also filed an application in Philippines, which was already being readied earlier last year, but was made public recently. So she also, I think, was trying to be quite open and honest, if you like, intellectually honest, and say, yes, we recognize the next step is to make an application, and we're committed to doing that. But also, I already put everyone on notice that we're at a breaking point. We cannot roll out these investigations. But of course, I think there is a very valid view that we should nonetheless seek authorization anyway. And then, if you like, hibernate the situation having obtained authorization. I think that is, of course, an option. And I think that was an option that faced the outgoing prosecutor. But she also recognized that there was a transition in place with a new prosecutor coming in, Karim Khan, who's now taking office. And she also said in that statement, of course, these decisions also impact on the future term of the incoming prosecutor, and she wants to discuss with him. And in the end, she discussed leaving those decisions for him to take. So the current prosecutor, Karim Khan, was obviously assumed office. He is currently studying and becoming familiar with all of the situations and cases in terms of the underlying rationale and support for them. He's in the process of reaching his view in terms of how to prioritize the workload of the office across all situations and cases. And obviously, the situation in Ukraine is among those that he's reviewing. And so it now falls for him to decide the next steps. But having said that, I think the title of the topic given for this presentation, is it a panacea, that was given to me by the presenters, indeed is the relevant point. Even if the prosecutor opens an investigation, even if we have the budget and resources to do it, of course, it should never be the expectation, and I think this is not the expectation in Ukraine, should never be the expectation that the ICC prosecutor then becomes the main or principal agent for the execution of the accountability mandate. Of course, even in the scenario where the prosecutor's office is able to roll out investigations, as you know from experience, the ICC prosecutor can only do a limited number of investigations and cases in each situation. Typically, you've seen in other situations, often no more than 2 or 3 or 4. I think the largest number in the DRC is maybe around 4 different armed groups involved. In some other situations, both parties to the conflict, but and then a handful of alleged perpetrators, ranging from sometimes mid-level to sometimes high-level responsibilities, sometimes notorious perpetrators, and so on. So, of course, the bulk of the responsibility will remain with the national authorities. And so to that extent, I think, of course, we've also been very keen to have this dialogue with both yourselves and with the authorities in the context of both the pre-examination, but also in the context of a future investigation about what we can also do to galvanize the efforts of other actors. And yes, of course, not only do we remain committed to complementarity and working with the national authorities to progress that, but also to lend support to efforts to adopt relevant legislation, particularly implementing legislation to cooperate with the court, as the previous speakers have said, is really crucial for us. Of course, as you know, legally, as the previous speakers have said, once the declarations are lodged with the court, this is an international act that carries responsibilities under statute. As you know, under the rules, Rule 44 says that the consequence of lodging these declarations is that the state is thereby bound to cooperate under Part 9, and all the relevant rules that apply to state parties apply to the state. And one of those rules is that Article 86, the state shall cooperate fully, and Article 88 says that the state shall have procedures available in its national law to allow for all the forms of cooperation foreseen in the statute. So, of course, we have had already some cooperation with the authorities. We've made requests for information in the context of the pre-examination. We've also had the opportunity to discuss evidence preservation issues. But moving forward to the next stage, of course, that legislation will be really important, because otherwise we'll come to a potential standstill. We need that legislation in place to allow us to be able to operate in the territory, to be able to conduct our own investigative activities, to have our privileges, immunities guaranteed, and so on, but also for the authorities to execute requests for us, including compulsory measures, orders, forfeiture orders, seizures, search and seizures, court judicial orders. If the domestic courts cannot recognize a request sent by the ICC prosecutor, or if the PGO cannot transform the ICC request into a domestic request to seek a judicial order, then really we come to a standstill. So I'll just stop there as just those introductory remarks, but absolutely, the court obviously is only part of a much broader framework, and our role may be in fact the least important in the accountability landscape, but we also recognize we have an important role to play and a responsibility to discharge. So I'll end there.
Okay, thank you very much, Rod. I think those were very useful for all of us to hear, and to actually start really doing something about it at the domestic level. Next, I want to give the floor to Toby. I mean, we've heard what Rod's just said about the role of the ICC, and obviously, referring back to the first panel, we already heard about the challenges that Ukraine is facing in terms of implementing the principle of complementarity. Based on your experience, what are the main challenges that a state is faced with when prosecuting and adjudicating grave international crime at the domestic level? Obviously, we've heard about lack of legislation, lack of infrastructure, serious safety and security risks that's been voiced here, not by the judge herself, but those who work with the judicial authorities. Of course, lack of resources, lack of political will, but most importantly, lack of understanding, appreciating how crucial these processes are, how strategically important they are, but also they are very fragile and complex. Do we have a recipe at all?
Thank you for the question, and thank you for the invitation. And just to make the comment, as you said in the introduction, I do still very much look forward to coming to Ukraine to have that discussion with the national institutions, because I think it's critical to be able to understand how the national institutions are operating in order to determine what kind of support they should get from the international community, so that it's directed to the interests of the national authorities. As I think many of us will know, that there have been a number of successes and failures by the international community, and we don't always learn particularly well from our mistakes. But I think understanding what should be done in the interest of Ukraine, I think, is the most critical. I think, as Fidelma will recall, the days that we worked together in Bosnia was full of challenges in setting up institutions there. I was fortunate that I only had one part of the problem, whereas Fidelma had three parts of the problem, which was the court, the defence, and the prosecution to manage. So I can certainly speak about the prosecution side. Just to make one comment on what Rod has very, very helpfully set out, I think that the important thing to remember with everything that Rod has said is that the ICC is not the panacea. I think the thing that you have to understand, as Rod has stated, that the ICC will only ever be able to deal, even if it was fully resourced, which we know it's not, even fully resourced, it would only be able to deal with a small part of the problem that Ukraine faces. And so I think that the national authorities have to understand they cannot defer responsibility to the ICC, because I think that would be a very negligent approach to what is a very, very important task. In terms of the challenges, I put down, I think that there are three critical areas that from the prosecution side that they need to consider, and more broadly for all institutions, that there is an effective and a solid legal framework that recognises the crimes that need to be investigated and prosecuted, that reflects sufficiently the law as it stood at the time the crimes were committed, that it provides an effective basis for the most grave crimes to be prosecuted under national law, incorporating international law. But more than that, I think, as many of us have experienced and continue to experience with international, national and hybrid institutions, it's having an effective regulatory framework that deals with admissibility of evidence, that deals with many of the procedures that the Criminal Procedure Code will not have in place. One of the aspects to this that we had to incorporate in Bosnia, which again was a painful experience, but it was one that had to be done, was how do you, effectively we had to have a separate law that dealt with the transfer of cases from the ICTY and the admissibility of evidence that had been collected by the ICTY. So I think what needs to be considered now is making the amendments to the criminal code for the substantive offences that are not in breach of Ukraine's international obligations on the principle of activity is one of the first important points to raise. That the crimes are sufficiently defined, taken into account international law. And I think that's another important point to take into account. One of the things which is often lacking in many of these ventures is actually having a framework for the elements of crimes, which we do have, of course, at the ICC, but we don't necessarily have in other tribunals. And it makes it very, very difficult for all parties to the proceedings to understand what needs to be proven if this is lacking. And so I think that's one area that does need to be considered. But then looking at the prosecutor's office in particular is having the various different protocols and internal regulations that deal with a lot of matters as to investigations, the role of investigators, the role of prosecutors, how you're going to deal with the collection and storage of evidence, how you're going to deal with immunities and privileges. So there are a number of different areas that we incorporated into the practice of the Bosnian Prosecutor's Office that was not contained in the internal rule book, was not contained in the procedure laws, but there had to be these policies in order, and transparent policies in order for the office to work effectively. The second point that was one of the greatest challenges for us in Bosnia, and I do remember many long discussions with Fidelma and other members, and that was the organizational structure of the office. When you look at investigating war crimes, it's not a matter of having a prosecutor who can delegate authority to an external investigator, and then that process to be managed by a prosecutor and effectively an assistant, which was the practice before we set up the war crimes chamber. But what we needed to have was a system of having a research and analysis capacity because of the nature of the crimes that are under investigation, by having an effective document management system and a secure document management system that enables information to be stored, to be analyzed, because quite often with these cases, you will have prosecution teams that are operating in different parts of the country, but there'll be quite a lot of crossover with their investigations. And so if you don't have these systems in place, you get a lot of duplication of effort. And I think that is one of the problems that we faced at the very beginning of our time in Bosnia that we tried to deal with. You need to have a case management system. You need to have junior legal officers assisting the prosecution, because these are very complex cases that require large teams, but require a structured approach. And you need to have a prosecutor, a chief prosecutor, who is able to effectively manage that process. And so I think the institutional capacity, the institutional setup of the process is as important, if not more important, than the legal framework. It has to be structured in such a way. One of the biggest challenges I think that you face is having limited resources, and that's the same whether you're the ICC prosecutor or the Ukrainian prosecutor, is how do you effectively manage your resources? And one of the issues is, and going back to Bosnia, there were grand announcements by the international community that every crime will be investigated and every victim will have their day in court. And that is unrealistic, and it's unfair to victims to actually set such high expectations. When you do have to manage limited resources, you have to be able to ensure that the cases that you are selecting for prosecution are those that not only represent the gravest crimes, but also have the greatest prospect of success. And a prosecutor's success is managed by convictions, of course. And so you have to understand that you will not be in a position to prosecute every single case. And so you have to be able to manage resources and manage expectations. Now, when we first started in Bosnia, there was a system set up for how cases were selected. And there was a great deal of criticism that the prosecutor was prosecuting what was called low-hanging fruit. So the easy cases that you can get into court quickly, that are easy to prove, but do not necessarily have any impact on the community that you're serving. So we had a prosecutor at that time called David Schwendeman who came in and developed a process of actually doing a mapping exercise of all the crimes that were committed for the duration of the conflict to enable those situations that had the greatest impact on those communities. Now, of course, in the Bosnian context, there was Srebrenica, where you have between 8 and 10,000 men and boys who were killed. And that's always one of those cases that is highlighted as the greatest significance, and of course you have to dedicate resources to it. But there were other cases that we found, smaller cases, where in one case in northwest Bosnia, for example, where the entire Catholic community was wiped out. Now, it was over 100 individuals, so it didn't compare in terms of the size to Srebrenica, but it was an incredibly important case for that community. And you have to recognize that a case of that kind has an impact. But you need to be able to understand the conflict as a whole in order to determine which cases are the most significant. And so this was taking a different approach to what some of the other international tribunals had taken by taking purely a victim-based strategy to case prioritization and case selection. But I think that requires having a detailed strategy on a detailed prosecution strategy, taking into account the limited resources that you may have. There will be great difficulties in you are creating the national prosecutors and the national investigators will not be familiar with, and that is a challenge that they are going to face. They're going to be dealing with a legal framework that they're not necessarily comfortable with, and that's going to require some time and some assistance. And there will, of course, be issues such as translation. I mean, translation was one of the biggest budgetary concerns that we had and continue to have. Whenever you have international assistance, you have to take into account that they are not going to be able to read the documents, they're not going to be able to speak the language. And so you have to factor in to what extent is it important to have that level of international assistance if the cost to translation is going to be so great that it makes the whole process unworkable. So there is going to be a requirement for training, for assistance. And I think one of the, and I always refer to Bosnia as one of the greatest models in theory. It didn't always work out in practice, but I think the theory behind the Bosnian model was very, very effective in that you have a experienced international prosecutor working side by side with a Bosnian prosecutor. And that enables the transition period than investing too much into the international involvement of the process. So I think I don't know how long I have to speak, but I think I've touched on some of what I think are the greatest challenges, and I don't want to speak too much on this.
No, yes, thank you very much. I mean, I'm sure we can talk on, and you know, there's a lot to discuss, and hopefully we'll get a chance when you finally get here to do what we've planned to do. So I'm just going to go on to Fidelma and ask her to expand on the issue of resources that Toby's just addressed to some extent. But I think this is something that we need to take into consideration when we are trying to build an accountability mechanism. And I remember from your previous presentation and your visit to Ukraine in 2019 that you touched upon this issue, but right now it's sort of getting a new light in a way, and this is something that we're really already trying to think about, and the risks associated with not planning, not considering the issue of the resources. And I mean, we have the example of the limbo situation with Ukraine and the OTP, the one that the ICC that Rod's spoken about, and also we've already seen what's happened to the special tribunal for Lebanon as well. And I mean, we've had this kind of worrying and discouraging examples, and I think it would be important for us to hear the expertise on how to broach this issue of budgets and resources, how important it is, because to me it seems like an entirely different issue, an entirely different weight that we need to pull, and I don't think that Ukraine's definitely not ready for it, in my opinion, but perhaps with international assistance there is a chance. Thank you.
Good afternoon, everybody. It's an absolute pleasure to be with you once again, and I thank the Ukrainian Legal Advisory Group, the Kingdom of the Netherlands, and the International Renaissance Foundation for the invitation. So far this morning, we have heard very pertinent remarks from Rod and Toby. Rod has clearly highlighted as has Toby, the need for complementarity. I think it's clear to everybody participating today that the desire to have an effective national system or specific institution to address accountability, working together with ICC will require the building of capacity within the Ukrainian system. Toby has correctly identified the need for an effective legal framework, the need for an organizational structure within any prosecutor's office, and obviously broader the criminal justice system to deal with crimes of this nature, as well as a strategy. My task, I believe, today is to emphasize that to do all of that, you will need to have the financial and administrative discussion to enable you to have the resources that you need to build the capacity that you need for an effective model of complementarity. So with that in mind, I would like to give you a brief overview of different models of financing of international and hybrid tribunals, with a view to also giving some of my reflections on the various models. And ultimately, I will join Toby in mentioning that I feel for the Ukraine, perhaps a model similar to that which was implemented in Bosnia may in fact give you some extremely valuable lessons learned for developing capacity. So as a general remark in terms of funding, international and hybrid jurisdictions have largely been funded from the budget of an international organization through voluntary contributions from interested states. A mix of both of those systems, or alternatively, funds have been contributed from states where actually the crimes have been committed. So to take a look at the first category, I'm sure that many of the participants might be aware that the International Criminal Tribunal for the former Yugoslavia, as well as the International Criminal Tribunal for Rwanda, now with their successor institution, which is the International Residual Mechanism, have been funded from the UN member states in accordance with their an agreed scale of contributions from those member states. Interestingly, at the inception of those tribunals, funding was an open issue, and it took a number of years for the funding structure to be settled, in the sense of it will come from the UN budget. The advantage of that vis-a-vis voluntary contributions is it is an extremely organized method of budget management, as well as seeking your budget on an annual or a biannual basis. Whereas I will come back to the voluntary funded system, which is a much more volatile system of seeking budget donations from member states. And with some of the examples I'll give you, there is a very valuable lesson learned, which is, and it's been touched on in the opening, there is problems, and funding crisis and lack of funds is something that's been encountered by institutions. Without going into too much detail, I think it's fair to say that when we look at accountability mechanisms, there is no ideal solution, and I think this is something that was touched upon by Rod in his remarks. The ICC is the Permanent International Criminal Court. It's financed through assessed contributions of the states that are party to the Rome Statute. Theoretically, its expenses could also be covered by agreement with the UN Security Council for situations that are referred to the ICC. That has actually never happened. But I think an interesting point that's been raised by Rod is that the Office of the Prosecutor has indicated that it has upscaled its work. However, it doesn't necessarily have the resources in its budget to meet the demands of that workload. And this is a really important central critical issue in building institutions, that in terms of the timing of planning your financial strategy, it really should be in parallel with the work that's going on regarding what you plan to do. Because in management of expectations, and Toby appropriately also raised this, if with a population you are saying we are going to do an enormous volume of cases, and you forget to have the consultation about how you're going to fund the system, then expectations will not be met. And what you've done is, at a very, very early stage, given the wrong expectations to people, and you will always be behind in your planning. So my very, very strong advice from setting up 3 tribunals is that at the table from the first days of planning, it's extremely important to match the resource planning with what you're actually planning in terms of, be it a prosecution strategy or the building of the national criminal justice system to be able to cater for those cases. So rather than financing being the technical and the administrative matters that we can deal with at a later stage, it really should be central and a central element of your planning from the start of discussions. An example of that is, as you know, I am registrar of the Kosovo Specialist Chambers. I commenced work as the head of the court planning team in 2015. And the first member of the court planning team was, in fact, a finance officer, because in terms of building the institution, it was absolutely critical that we were in a position to inform the member states what finances we would need to deliver on the mandate that was set out in the law adopted by the Kosovo Parliament. So this institution is funded from the EU. We also have contributing states, which are much more like, if we speak towards voluntary donations. We have an example of that is Switzerland, that has donated with a grant agreement with myself on 2 occasions, approximately 350,000 euros to support our outreach work. In terms of how we manage that grant, that's an agreement I have with the Swiss government, but it's an example of how you can be funded from, in this case, the EU on a biannual basis, but likewise, we can still receive grants from other countries. Next. Can you hear me now? Thank you, apologies. So I will turn to voluntary contributions and institutions funded by them. And in terms of the challenges and the reality of managing hybrid tribunals, I'd like to look towards the Special Court for Sierra Leone, which was established in 2002 by agreement between the United Nations and Sierra Leone. The Secretary General's report on the establishment of the tribunal specifically noted, and I'd like to read this to you, that a financial mechanism based entirely on voluntary contributions will not provide the assured and continuous source of funding which would be required to appoint judges, the prosecutor, the registrar, to contract the services of all admin and support staff, and to purchase necessary equipment. The risks associated with the establishment and operation of this kind of tribunal, if there is insufficient funds, are without long-term assurances of continuous availability of funds, very high in terms of both the moral and responsibility and loss of credibility for the UN. So in the end, in spite of this consideration from the Secretary General, the Special Court for Sierra Leone was funded from voluntary contributions. Very early in its history, the voluntary contributions were not sufficient to meet the budget needs of the court, and the court had to seek a subvention grant from the General Assembly. I can say, having been Deputy Registrar of the Tribunal, two key elements in that experience. One, the risks are very real, because during my time at the court, once again, we had to seek a subvention grant because there simply wasn't enough money in voluntary contributions to fund the operations of the court. However, the reality was that there was no other funding mechanism available. So ultimately, what it means is that if you're funded from voluntary contributions from interested member states, it is unequivocally a full-time job, and you need to have the resources within the institution to continually fundraise, to manage multiple grant agreements with member states, to audit those grant agreements, and inevitably, and this was something that was also noted from the Special Court of Sierra Leone, you will have senior figures who will have to spend a considerable amount of time on fundraising. It's just part and parcel of the reality of managing an institution with voluntary funds. That said, the Special Court for Sierra Leone, established in 2002, transitioned to the residual Special Court in 2013, and I think by all accounts, it has done a very good job in delivering on its mandate, in spite of all the challenges from its funding mechanism. Now I'd like to turn to a point that was raised by Rod, which was that the OTP, in terms of workload and resources, is at a breaking point. So what happens if there isn't sufficient funds to cover the operations of the institution? I've shared with you the scenario of the Special Court for Sierra Leone, where as a consequence of funding crisis, they received a subvention grant. The Special Tribunal for Lebanon has been mentioned, and most recently it has faced a very drastic situation. So how has that court been funded? The agreement was a mixed system in terms of covering the budget, where the Lebanon covered previously 49% of the budget, and voluntary contributions from member states covered 51% of the budget. Less than a month ago, the registrar of STL announced that they did not have at their disposal the necessary funds to continue its activity. So we see a very drastic situation there where efforts perhaps to get the funding from member states were not successful, and as a consequence there's a knock-on impact on the work of STL. I'd now like to turn as a final set of comments to perhaps, as I mentioned, a model that would be something for the Ukraine to consider in terms of adapting lessons and potential ways to build domestic capacity, but also potential ways to fund the building of that capacity. I have frequently referred to the Bosnian war crimes and organized crimes chambers as an extremely solid model of complementarity in practice, how that can be implemented, particularly in cooperation with ICC and at the domestic level. So the war crimes chambers and the philosophy behind the war crimes chamber was to build a sustainable domestic capacity for the prosecution and fair trial of cases of war crimes and crimes against humanity, rather than going down the track of building a separate hybrid court with a defined lifespan. In terms of the implementation of that system, we initially held an international donors conference in 2003, and we presented at that donors conference the plan. And the plan was that over a 5-year period, we would introduce international expertise into the domestic system, where that international expertise was needed to build domestic capacity. And through the 5-year period, we would withdraw the international involvement with the aim that at the end of the 5-year transitional period, the domestic institutions were in a position to be able to implement their respective mandates without international assistance. What was key in terms of our presentation to the donors was that was a resource management plan, but with that plan came the funding plan. So for us, it was indicated to the donors that we needed 16 million euros, approximately $16 million for the first 2 years of operations, which meant we could increase resources, i.e. internationals, to work in the institutions, but also take care of very basic logistical matters like building courtrooms that had translation booths and capacity for translation, building a 21-bed maximum security detention facility, as well as other infrastructure projects. And then after that, we could, through the 3-year period of transition, start to withdraw internationals. We were successful at our first donors conference and received, I think it was approximately $18 million. And at our second donors conference, we sought another $16-17 million, which thankfully from voluntary contributions were successful in receiving that funding. So ultimately, I think as a methodology, that was very, very positive, because in terms of working with the states, we were not only seeking their support for the institutional development of an accountability mechanism, in tandem, we were presenting to them a long-term funding strategy. And the key element of that funding strategy was that all of the national staff in the institutions in Bosnia were initially, for the 2-year period, paid from international funds. And at that period of time, we were working together with the Ministry of Finance of Bosnia for the transition of those staff to the domestic budget. So everything was progressive, it was phased, and it was supported in financial planning by a team of people that worked within the court. I think Toby is right. We learned some valuable lessons in terms of that model. But overall, I'm glad to say the institutions are still working, and that the national staff that were transitioned to the state budget are still being funded from that budget. So with that, I once again thank you very much for the opportunity to make some remarks on a very complex topic, but I hope they will help to guide the discussion, and I'm happy to answer any questions people may have. Thank you.
Thank you very much. It was so useful, and a lot to think about as well, because I remember from one of our discussions with Toby, he was saying that Bosnia was, and this is something that sort of the main difference between the situation in Ukraine and Bosnia, while Bosnian model might be the optimal one for Ukraine, but also Bosnia was sort of, there wasn't a choice, because the cases from ICTY had to be transitioned to the domestic courts, and obviously there was a sort of an understanding and consensus and support of the international community for this transition, and that's where the support came from, I suppose, whereas Ukraine is not sort of in that situation, and obviously there's a lot of advocacy work that will need to be involved, and that's where I would ask Matt to come in, because obviously not only he's very experienced in advocating on the issue of budgets, but also he's also experienced generally in advocating the international justice-related issues. And so I'm just going to ask you to share your experience and perhaps your recommendations. Considering from everything that's been said, and you're sort of more or less familiar with the situation in Ukraine, of course, we sort of one step towards, or maybe 10 steps already, is just one more step left to implement the legal framework, and obviously infrastructure is not even, it's very fluctuating. We one day we have the department, next day we might not have it, and it's just, too many fluctuations, too much of a fragility, too many risks. But what would be your take on the situation? Thank you.
Thanks, Nadia, and good morning, everybody. Good afternoon. Firstly, thank you to you, Nadia, and all of the organisers for having me and having me to speak. I will address your question quite broadly, if that's okay, Nadia. I'd kind of planned to talk a little bit about some of the engagement and work that we've done specifically around the ICC, but also around working with war crimes units, as you mentioned, national level initiatives, and also perhaps sort of more broadly in a Rome Statute system of international justice. Just to pick up on your first point, though, yeah, on the budget. The one thing around the budget that I think is inescapable as kind of an elephant in the room is no matter how well proposed a budget can be put forward by the court and by Rod and his office, it's often a political decision by states not to give that money to the court, no matter how well argued a budget might be. And I think we also need to acknowledge that there is very much a political element often around those discussions, especially if it's an institution that might, like the ICC, start looking into areas and countries where states who are supportive, where their interests start being affected. We can really see how changes might happen in and around the budget, and also absolutely to agree with Fidelma that often if you want to see what the court can or will not be able to do in the coming year, that the number one place to look is in the budget proposal. Because obviously if it's not budgeted for, it likely won't happen. So I'm happy to reflect on the budget, but I think it's a bit dry for me just to say it's exceptionally difficult. year on year to get states to provide that to the court, and we're always trying to think of ways that we can to sort of ensure that happens. But even sort of providing what may or may not be able to happen with a given budget doesn't seem to be enough. So honestly, I can't say that there's a sort of golden answer to that question, but I'm happy to come to it again at the end. But in terms of my presentation, yeah, happy to talk about civil society organizations. Just to say, of course, that I'm certainly in no way the authoritative voice on civil society activism or organizations, but hope to offer some reflections. We published a report this year, Amnesty International and the Asser Institute, in May, which was entitled "The Rome Statute at 40," and that reflected on the role of a number of diverse stakeholders, including NGOs, within the Rome Statute system writ large. Nadia, you were very kind enough to attend, and I'll also draw some observations from that. So generally, let's start with over the last 20 years, some of the engagement of NGOs with the ICC and in the Rome Statute system. I think it's obvious that any accountability mechanism, the ICC or any other, will rely on many different stakeholders to succeed. They play many different roles, number of factors, but related, of course, to political issues, financial issues, mobilizing political support, mobilizing support of affected communities, many different roles. At the ICC, as I think we know, the NGOs and civil society organizations were very actively involved in pushing for the creation of the court, the adoption of the Rome Statute, as well as being involved in the foundational aspects of the court and its institutional policy framework, its rules and its regulations. And I think there's really a critical role there for NGOs, CSOs in Ukraine to be involved in the design of any international justice mechanism. In fact, I think that would be essential. As the court, as the ICC has sort of become more of an expert of its own trade, the NGOs perhaps provide more sort of specialized input relevant to issues that the court still requires or may want expertise or input. So around, for example, sexual and gender-based violence issues or victims' rights issues, but also fair trial issues, defense rights issues, which are absolutely critical to any international criminal justice process. Just to give an example, we were quite actively involved recently in even the establishment of this IIIM mechanism for Syria. And I always forget what the 3 I's stand for, so please forgive me on that. But we were involved there around particularly pushing for outreach issues, ensuring that there was liaison and cooperation with NGOs and affected communities built into the design framework of that institution from the outset, which I think was very important, and allows, again, facilitates information providers to readily access the institution or the mechanism. Then, of course, I think that there's a role to be played generally around monitoring an institution as it moves forward from a sort of, like the ICC or others, from a theoretical diplomatic or exercise into something that actually has to work, investigate, prosecute, undertake cases. I think the role of any NGO, civil society, or anyone interacting stakeholder will change. And again, that's about holding the institution more to account than it is for working on its active establishment. One thing I would say about NGO activism with the ICC, which I think is almost unique to it, is the way that the engagement with stakeholders has become somewhat institutionalized. It's almost an institutional element of the ICC now, also within the Assembly of States Parties to the ICC. And again, I think that's a critical element for NGO CSOs to consider at the outset of their work on the mechanism, is to start institutionalizing the nature of that engagement with it. And of course, the role of NGOs, and I was particularly struck by Alexandra in the first session, the role of victims organizations who are really able to speak with affected communities directly about what mechanisms are, really able to understand what the justice needs of affected communities are, as well as organize visits for mechanism staff, ICC staff to affected communities, conduct trainings, all sorts of things like that is absolutely critical. In terms of some critical reflections on engagement with the ICC, and I think, yes, it's ICC focused, but I think these can transpose themselves to any new mechanism, and I provide them for that reason. One interesting thing to think about is when to criticize a mechanism or an institution and when to support it. Criticism is seized upon quite often by detractors of a mechanism, by detractors of an international justice process. And I think that maybe over the last 20 years has led to some NGOs not being as critical of the ICC perhaps and other mechanisms as perhaps they could have been or should have been. There's also an element that criticism may also affect your access to an institution. I think that's a really interesting element to consider up front. Another one is about being too close, or what distance to maintain as an interlocutor with a mechanism. You obviously need to be sort of close to it in a sense of meaningfully and sort of impactfully interacting with it. At the same time, for any CSO or any organization, I think being too diplomatic or being too much as being seen as part of the system itself causes problems around perceptions of independence or objectivity, or becoming part of the system which you aim to critique. I think another critical observation would be certainly as we've now had a number of decades of international justice mechanisms, is to really include practitioners with experience of ICL processes within the design of mechanisms and also within the community of stakeholders. Certainly those who understand international criminal processes, those who understand international criminal trials, defense issues, victims issues, who built up expertise over a number of years and are then well positioned to be able to comment or critique approaches to international criminal justice. And perhaps most crucially, and there's still so much more to be done on this, I think, at the ICC, is the need to include the views and participation of people who have lived experiences of international criminal justice, as well as affected communities, in discussions around design of mechanisms, in discussions around international justice processes, and to ensure that spaces are opened up for affected communities or those or victims to engage directly and more assertively with international criminal justice processes and in the field as well. I think for us, a key question going forward, and what I think is very relevant to the discussions today, is how to situate impactful and effective advocacy in a broader system of international criminal justice, which is made up of complementary justice processes and initiatives. Personally, I don't think it's possible anymore to consider international justice advocacy on just one level, national or international, or on one particular mechanism, even the ICC, without taking a much broader strategic, systemic approach to comprehensive international justice. I don't think you can think of advocacy on one level or with one mechanism without considering how that might relate to or impact on another justice-related process or truth, reconciliation process, reparations process. I think this is largely built on what Rod said at the beginning, which is to recognize that one mechanism, the ICC or others, cannot do it all. So there's really a need at the outset to identify different justice options and avenues to meet as much as possible stakeholders' aspirations and justice needs. With the ICC, I think it's now fairly well recognized that it can be most effective if it works closely as possible with other mechanisms where that's possible. Obviously, that requires interlocutors on the national level, for example, who are willing and able to do that, and that's not always the case. But I just to highlight the point, I really don't think anymore we can see international justice as either the ICC or an international mechanism or states. I think it really needs to be much more holistic than that, and then we can start thinking about complementary justice strategies, which may be long-term, short-term, divisions of responsibilities between different mechanisms, different actors, different judicial activities, investigations, prosecutions, and strategies around, which perpetrators in a particular mechanism may investigate and prosecute, and where others may do that. And I think that's part of a much more holistic international justice work that we're now doing. And of course, I don't think we can lose sight, and I don't think anyone has, but I don't think we can lose sight of national systems. And really, and maybe in the last 20 years of the Rome Statute, this was somewhat lost, is really reiterating that the primary responsibility to investigate and prosecute rests with states and rests with national authorities. And with that in mind, I think with Ukraine and in other countries in which we work, we really try and impress upon all stakeholders how to harness the Rome Statute and its framework and some of its institutional design as much as possible in their work, and then obviously tailor it to their own justice needs. And then once we've moved into domesticating international laws or establishing war crimes units, for example, actually getting those war crimes units to be effective, or for states to actually implement what they have actually just domesticated, is actually probably even more of a challenge. With war crimes units, for example, once you've established a war crimes unit, trying to get interagency cooperation amongst those who are working on the same issues can be as much of a challenge as establishing the war crimes unit. Or, for example, once you have established national level proceedings, ensuring that victims and those affected actually can realize their right to complain or their right to actually go to a court, gain redress and reparations is as much of a challenge as it is to establish a war crimes unit. So that's just to think somewhat further forward. And then obviously around the issue of political will, and I know we spoke a little bit about that in the first session, but I thought I might just touch on that. And I think to say, of course, at the national and the international level, that just remains an enormous challenge. I don't think there's a one answer fits all solution to how you would engender political will. At the same time, I think, you know, NGOs, CSOs, maybe working as networks or in coalitions can play a coordinated role in that. If there's a sort of a coordinated strategic advocacy on a national and an international level of a group of interested stakeholders, I think that's very important. I read somewhere that, you know, one really important way to galvanize and mobilize public opinion is if you have good organization, good ideas, and good arguments. And I think, you know, building on those three pillars would be really important for some sort of coordinated advocacy. And again, how to ensure that coordination happens, and what to build around, I think is an ongoing question. But, you know, if you take a sort of broader conception of accountability, which includes victims and other stakeholders, but also different needs and what, you know, different stakeholders, different groups are asking for. So prosecutions, but also, you know, identifying missing persons, broader concepts of truth, justice and reparations, and try and coalesce around those rather than one particular mechanism necessarily or one particular process. I think that might be quite an effective way to do that. And then on political will, just to say, in terms of strategy, I think we always would be thinking about top-down approaches, so senior governmental figures approaches, but also bottom-up activism. So, you know, grassroots activism with affected communities, and how to blend those two approaches. I still think there's a traditional role for NGOs and stakeholders to play in agenda setting. I think monitoring states' compliance with their obligations, fact-finding on the national level, praising or shaming states, increasing the reputational risk for states on an international level. And the national level, I still think is quite effective, and a role that, you know, certainly Amnesty, we're quite fiery in trying to do that. One idea which came up in the Rome Statute of 40 discussions we had, which I quite liked, was how to instrumentalize a state's own theoretical commitments on the international stage and translate them practically on the national stage. So where a state might say, international criminal justice is really important, and we fully believe in the principle, well, actually holding them to account on the national level to what they've been saying at the UN or in the Assembly of States Parties meetings or in other fora, I think can be quite effective. And I'll end with this. I also think, and Toby touched it on others, I think there really is a role for CSOs to play in highlighting, you know, the boundaries and limitations of justice mechanisms and processes, as well as the possibilities that are available, particularly to those affected by international crimes. I think it's important to highlight that the ICC or any other mechanism will not work in a silo, but needs to be complementary to other efforts, and that will have a key role, I think, in highlighting the complementary nature of holistic international justice, but also a role in managing expectations of any particular mechanism, which I think would be much more positive in the long run too. So I think I've spoken for too long, but thank you for the question, and I hope I just about answered it. Cheers.
Thank you very much. Yes, you've answered it really well and gave us a lot of food for thought, definitely. So that Matt's presentation concludes this panel. I was wondering if there are any questions, any comments, anyone would like to, maybe someone from the panelists would like to make further remarks that they, you know, didn't think they had time to make. Okay. Okay. I think if there are no more questions, no more comments to make, I think this whole discussion has been very thought-provoking, and obviously we started off with trying to assess and place where these justice-related processes currently in Ukraine and what we need to think about, and for that we're very grateful to our international panelists, because obviously they've got this experience, they've gone through these processes, they've managed to draw conclusions, best practices, and surely this is something that we cannot ignore when we're trying to look for an effective model of justice and accountability in Ukraine that would help us ultimately to bring us to peace and reconciliation. And in this regard, I think we've already done, I mean, that was the exercise to do the mapping, really, of the issues that we need to start thinking about, and not just, you know, us as NGOs, as donors, as Matt mentioned, it's a holistic process and all the stakeholders need to be involved, and we all have to be motivated by the same goal and by the same result. And I hope, you know, state authorities realize this, victims realize this, and also NGOs and the states who are interested in supporting Ukraine in its endeavors to implement justice-related processes effectively. We all have to sort of agree that, you know, we need to be on the same page and we need to work together towards these goals. Thank you very much for your interest and your support and your comments and your feedback, and we'll be back. Thank you very much.